Hello, everyone, and welcome to CEDR's mediation case law update for 2024. As Frederick said, I'm Richard. I head up CEDR's commercial dispute services team, and so we arrange mediations and other ADR processes. So I'm moderating today's event, and so I'll be asking our speakers about these recent developments in mediation case law and procedure, and what this means for you as lawyers and for your clients. We're very fortunate today to be joined by two fantastic speakers who are both experienced lawyers and CEDR mediators. And I would like to start by welcoming them and ask them to introduce themselves. Firstly, Tony Allen. Tony, very good to see you. And perhaps you could say a few words by way of introduction.
Yes, thank you. I was reflecting on how long I've been in the frame here, and I realized that last century I was a practicing lawyer doing personal injury and clinical negligence mainly. In this century, I've been working full-time in mediation, first as a director of CEDR for 11 years, and then thereafter as a mediator, particularly, again, specializing in clinical negligence. But this, and particularly my time at CEDR, has given me the opportunity to reflect and write quite a bit about the place of mediation in civil justice. And I hope that that is going to be something that's particularly relevant to the discussions that we have today.
Thank you very much, Tony. And we're also joined by Kelly Strickland-Coutinho, who is a practicing commercial barrister and a CEDR panel mediator. And Kelly appeared as counsel in a very important case that we are going to discuss shortly. And Kelly, I know you do other things as well. Perhaps you could introduce yourself.
Sure, and I should just fess up that I have slightly less experience than Tony, but I'm very happy to be speaking alongside him. So, Richard, as you say, yes, I am in practice both as a barrister at 39 Essex Chambers, and I'm also a mediator, and I mediate obviously with CEDR's panel, but also at 39. And you're quite right to say, I think one of the reasons I might be here for this conversation is that I had the great pleasure of being junior counsel led by Edwin Glasgow on the Churchill case, representing the joint intervention by CMC, CEDR and CIR. Well, I think as the two of you know, I've recently been announced in the mediation context to be the next chair of the Civil Mediation Council. I'm not yet in role, I start in June.
Thank you very much, Kelly, and that's fantastic news, and congratulations on your appointment to the CMC chair. And moving on to what we're talking about today. Today is CEDR's mediation case law update for 2024. And for fans of mediation case law, we have some very interesting and exciting developments to talk about. In late 2023, the Court of Appeal issued a very important judgment in the case of Churchill and Merthyr Tydfil, confirming that courts do have the power to stay proceedings and order parties to engage in mediation. And in the past few days, the Civil Procedure Rules Committee has commenced the consultation on some important draft changes to the CPR with regard to the relationship between mediation and ADR and litigation procedures. So today we're going to try and look at these developments from the perspective of legal advisors and how these changes could affect legal practice. And we will try to consider the impacts on a variety of different types of litigation, from multi-track cases to small claims, and on the different types of clients involved in litigation. So firstly, perhaps we can look at the Churchill and Merthyr Tydfil case. Tony, what happened in Churchill, and why is it so important?
Well, it changed thinking on a very radical way that had been in place for 19 years. I was actually in court during the Halsey appeal back in 2004. And I think much to everyone's surprise, and Kelly may be able to echo the surprise in the way that it emerged at the Churchill hearing, we suddenly found ourselves in a case where it was really a question as to what happens when parties offer inter-party to mediate and you turn it down. We found the court pronouncing that courts could not order parties to mediate, unwilling parties to mediate, because it would offend Article 6 of the European Convention on Human Rights, in that it would be an unacceptable obstruction to the road to the courtroom. It came as, I think, a surprise, because it didn't appear to have been flagged up much in the in the skeleton arguments that were lodged beforehand, but it certainly hit the world very firmly. And although judges had been making orders up to that time, it stopped overnight when Halsey came. And although Halsey was mainly still about the question as to when do you sanction or when do you not sanction people for refusing to mediate between parties, there's no doubt about it that a slight chill fell on the world of the development of mediation. Sanctions were still imposable if you unreasonably refused mediation, and the case that had started that, done it in Railtrack, still remains good law today. But Halsey certainly put a general chill on the situation. A chill which Lord Dyson himself said to a conference in 2010. It was realized that in principle, perhaps Halsey wasn't sound, but it's still taken 19 years to get to this point. And even in 2023, a judge felt, in the case of Mills and Reeve and Martin, that she couldn't order someone into mediation because of the effect of Halsey. And indeed, the deputy district judge who heard the case of Churchill in the first instance felt equally inhibited by Halsey, even though it would appear that he wanted to penalise someone for not seeking to use some kind of dispute resolution. So in a sense, it's been a question of 19 years waiting for the right case to come along, and in the odd way that the court common law works, it certainly happened to be a case of Japanese knotweed, which led to a decision that could allow the Court of Appeal to look at things again.
Fantastic. Thank you very much, Tony. Kelly, you were one of the advocates in Churchill. What is your take on the judgment, and what do the lawyers, the practicing lawyers advising clients, need to know following that?
Good question. Thank you, Richard. I was at a conference recently, and Lady Justice Asplin, who has been very involved in the development of ADR in the UK and is actually the chair of the CPR's ADR committee, described Churchill as the real game changer for ADR. So not just counsel talking about their cases, but actually somebody of significance here. I think that there are two interesting things here. Thing number one is that Churchill obviously means that courts can now order the parties, even if they're unwilling, to go to ADR. That is a very significant change. One of the interesting things that come out of Churchill is what are the conditions under which that might happen. The court chose not to specify or give a tick list as to what exactly might be appropriate or what might be the factors that might be under consideration, although it did set out some or accept some that the Bar Council had put forward, which might be relevant. So on the one hand, the courts are now in a position where, should they wish to do so, they can order parties to mediate, even if they are unwilling to do so. That is of itself significant. And we're going to come on to talk a little bit later about some proposed changes to the CPR to give effect to Churchill. But essentially, that is a very significant change. But what that does, in my view, is it fits within the wider fabric of how ADR is being considered in the civil justice system at the moment. And I think one of the really crucial things about Churchill is that in effect, it's one puzzle piece amongst many, okay? And when I talk about the other puzzle pieces, the other things that I'm thinking about are mandatory mediation that is now in place in relation to small claims, and the other things which might be happening in future in relation to mediation in the civil justice system. So I think from my perspective, there is the literal possibility that orders can be made, but alongside it, there is real support now amongst the judiciary for ADR processes on the whole. And to my mind, that has the potential to lead to a cultural shift in how ADR is used alongside litigation.
Thank you very much, Kelly. So it seems that we have a package of measures. We have some case law, and we also have the draft changes to the civil procedure rules, which I think are part of a consultation at the moment. So Tony, if I can pass this over to you, what does this mean for litigants in terms of what they need when they need to think about ADR and engage in ADR?
Well, I don't think that any litigation lawyers is really going to be able to afford to not to think about ADR from the very start of acting for a client. It's going to be built into the strategy of their approach, and it might actually make quite appreciable changes to the landscape of litigating, which is always an uncomfortable thing for any lawyer to confront. But nevertheless, I think it's inevitably going to happen. And perhaps that is underlined by the proposed changes to the CPR, which are under consultation at the moment. It doesn't seem more than a minute or two since Churchill was decided. The common law normally takes 900 years to do things sensibly, but you know it's moved quite quickly on since last November. And the Civil Procedure Rules Committee set up a subcommittee to talk about what the implications of Churchill were and how they should be seen to impact on the civil procedure rules. Some of us thought, well, there might be a little bit of tinkering with CPR3, with the case management powers section, where already there's a provision for judges to order judicial neutral evaluation against the will of a party who doesn't like it in 312M. But lo and behold, the consultation, which is a short period of time, they're expecting answers by the 28th of May, went much further than I think any of us immediately expected. We suddenly find an addition to the overriding objective. We find that now dealing with a case justly and at proportionate cost includes the things that it always did, and particularly since the Jackson report's proportionality, but it also includes using and promoting alternative dispute resolution. Now, that is an earth-changing change. Anything that finds its way into the overriding objective is supposed to stick in the mind of judges and lawyers as a paramount consideration. And if one goes on through these proposed changes, Part 3, as one might have expected, adds a paragraph which says that the courts have got power, may order the parties to participate in ADR, which is, of course, precisely what the Churchill court found. Parts 28 and 29, giving directions in various kinds of case, particularly in multi-track cases. Directions hearings must deal with the issue of whether to order or encourage the parties to participate in alternative dispute resolution. And lo and behold, something that I found myself writing about even before the CPR came in, actually, or shortly after the CPR came in, before Dunnett was decided, CPR 44, which of course covers the question of cost sanctions and how courts might deal with misconduct by parties, includes now whether a party failed to comply with an order for alternative dispute resolution or unreasonably failed to participate in alternative dispute resolution proposed by another party. That's something, as I said, I've been arguing for years, and here it is in black and white. So very, very swiftly, changes have been proposed, consequential changes in the CPR, which implement certainly a straightforward interpretation of what Churchill actually decided.
I think, Tony, there's something really interesting there around the fact that it's in the overriding objective rather than put into a separate part or put in specific places. Because to my mind, I agree entirely with what you say about this being of such significance that we have to consider it. I say we as a lawyer, but we have to consider it at all points in a dispute. But of course, it also it picks up that point that ADR might be appropriately used in whatever form a court thinks is appropriate across all sorts of points in a dispute. And, you know, I think one of the really key things about this is because of that breadth of use of the power in the proposed changes to the CPR, I think that means as a lawyer, it's very relevant to start thinking about what your ADR strategy is alongside your litigation strategy right from the outset, really, pre-action, and to continue to think about it. Because, of course, if the power is to be there in the overriding objective, as the consultation says, then we as lawyers must consider it at all points. And there are going to be pinch points in a dispute where ADR might be more helpful, and there are going to be points when perhaps ADR is not quite the right thing for the parties at that particular moment. So I think the significance of it being in the overriding objective is really interesting.
Yes. It seems to me that, luckily, I go back to the days before the CPR came in, and in the early days of mediation being introduced in civil justice and in civil claims. And in those days, everyone was slightly afraid that if you proposed mediation, it was a sign of weakness, and you were signaling that your case wasn't strong enough, and you really wanted to try and do a deal if you possibly can. And in a way, that fear can be got rid of by the fact that, in effect, mediation is now something that mediation is the main process, really. The fact that, in a sense, you feel that it's got to be considered means to say that your opponent will not think that it's a sign of weakness. In fact, you might be exercising some degree of power over an opponent if you propose it by putting your opponent on the back foot as to whether the opponent should say yes or no to it. So it's going to really put an end to that fear that proposing it is a sign of weakness.
I couldn't agree more, Tony. And I think there is, of course, on the one hand, I suspect you've been in mediations, as have I, where the parties get a bit tangled up about wanting to tell the mediator who proposed the mediation, as if that's going to make a real difference, because there is that dynamic of, is there a weakness in proposing a mediation? Yeah. And of course, the other thing is, as a lawyer advising litigants, I would want to be quite careful to be sure that I've advised appropriately at the right times to consider, because it is part of what the court expects now.
Thanks. So Tony, we've got the CPR changes, and there's a mediation, or ADR is now mentioned in the overriding objective. It's mentioned specifically in the court management powers. It's mentioned, I think, in parts 28 and 29 in relation to fast track, intermediate, multi-track cases, and the cost sanction is emphasised in part 44. Kelly, as a practicing lawyer, does the Churchill and these proposed CPR changes, are they going to apply to all litigation cases? And can you conceive of any situations where you may not need to use ADR or consider mediation?
That's an interesting question, Richard. I mean, given that it's going to be in the CPR, if the proposed changes go through as anticipated, it will, of course, be everywhere that is governed by the CPR. There are obviously tribunals and so on where the rule change may not flow through, because the CPR rules will change perhaps differently to how tribunal rules change. But the underlying point is very clear that a court, and I would say in this instance a tribunal equally, could make an order for ADR. I suppose some tribunals might be troubled by the question of whether or not they actually have the power to do it. But given where the court is, where the CPRC is proposing to put it in the rules, I would anticipate there probably wouldn't be too much difficulty in getting there. And I think one of the interesting things is around not just how it applies in court, but to my mind, I'm very interested in the idea of what happens when ADR is expected to be a part of the civil justice system, or your strategy in dealing with a dispute. Because that means that if ADR is so thoroughly encouraged, it also means that parties to litigation who might find other ways of resolving their dispute than bringing claims or responding to claims do have the opportunity to set up something different. So you might, for example, if you're a very large business or a government body, consider something like setting up a bespoke ADR process to deal with potential claims and so on.
And of course, with ADR contract clauses, that is or has been happening for a long time, and courts are pretty tough about making sure that people comply with their self-imposed processes.
Exactly.
So we're now turning just consider the impact of these changes on clients of all different shapes and sizes. So from large organizations to small businesses. Tony, perhaps I can ask you, do you have any thoughts on how the changes, or what clients and businesses should be thinking, perhaps of lawyers advising them as a preventative measure in light of Churchill, what these clients should be thinking about?
Well, I suppose that there are very, very broadly two types of client. There's the client, the last place where they want to be wasting their time is in litigation. And they will, I think, welcome the opportunity, rather than having to spend resources and time on preparing cases for litigation and assembling witness statements, going through e-discovery and all the huge travails that are involved in litigation. They will be only too glad that there is a relatively easy way, at least, of seeing whether that can be avoided. That kind of client, I'm sure, will welcome what their lawyers will tell them about the availability of an alternative process to bring things to a head at an early stage. I mean, I'm old enough to remember, of course, the court door settlement, that abomination that frankly dominated litigation for years and years and years, having had clients weeping in a wheelchair outside a court while people in silk gowns swept to and fro deciding their fate and advising them in the last minute. I have always been absolutely dead set against that kind of thing, and delaying things through to the very end just in case is not something that I think is proper advice for people to give. The other kind of client, I guess, is the really aggressive kind, who hates the CEO of the other company, or really feels that they have been really done down by someone else. And their lawyers are going to have to calm them down. Will be able to say that there is this kind of event which is pretty well unavoidable. We'll perhaps talk about timing of the use of ADR in a little while, because I think that is something that's important. There's still something to be thought through by lawyers carefully with their clients. But the aggressive client, in a sense, needs to be told that actually there is an opportunity within a mediation, a confidential environment, a secure environment, for them to see whether there's a way out, rather than they're really indulging their aggression in terms of of their feelings about a dispute. And having remembered a mediation where I said to both lawyers, it was open warfare between you up till 5:30 last night. And of course, you are absolutely free to resume hostilities at 9 o'clock tomorrow morning. But here's a day when you can try a different approach. And the thing settled miraculously by about mid-afternoon, and just giving people the opportunity of behaving in a different way without in any way compromising their aggression on the record seems to me to be a hugely valuable offering.
Thanks, Tony. So really persuading clients to take, I guess, a more pragmatic view of settling disputes in an early stage. Kelly, this is the same question for you about what do you think are the impacts for clients to think about of the Churchill decision and the CPR changes, and how does that affect clients in different ways, if depending on their size and type?
Sure. I think, if you don't mind, I'm going to start with the large commercial clients, because it strikes me that there's a lot of opportunity here for large businesses. And I hinted earlier, I think, that the idea is that ADR is becoming very much more firmly integrated into the dispute system, and that large commercial clients do have the opportunity to set up their own bespoke type ADR processes. And I should say, I'm using the word ADR despite the fact I really dislike the alternate bit of that, but I'm non-court-based dispute resolution, which is the term that was used in Churchill, is a bit of a mouthful. So I'm running with ADR at the moment. But what I do want to highlight is that actually the processes that large businesses have the opportunity to set up to settle their disputes, number one, don't have to be really thought of as an alternative anymore, or as a thing which you do to avoid litigation. And the second thing that I think is really important is that sometimes, particularly at the moment, you see issues where there are, of course, legal arguments about all of the sophisticated points you might see, but there might also be commercial reasons why you want to look at a particular issue and deal with it in a particular way. There might be reputational type issues. You know, for example, it may be that as a large business, you accept that something you've done has caused some harm, but perhaps your litigation strategy might have been that were you to force everybody to go to litigation, you may win some of those. Now, that might be quite an unattractive position to put those people through if you have reputational concerns alongside, or, for example, if you have a commercial reason why you want to get this thing sorted out and moved on from. So what I'm saying is that the opportunity to set up bespoke processes here is quite interesting, because you can do that, and it not only is it not very alternate anymore, but it can also deal with some of those wider aspects of commercial and other type issues that litigation simply won't do, and won't do in the same way in terms of timing and so on. So I think there is something really interesting there. And I would also say for large businesses, I think sophisticated litigants will be expected, because of the changes, to consider ADR rather more seriously than perhaps they would have done so far. I think it will probably be a little harder for lawyers to say, well, we don't need to go to ADR just because it's that type of a case or because it's got those sorts of issues. I think the court will now start looking rather more carefully at why parties are choosing not to go to a form of dispute resolution. I'm not convinced that there are going to be heaps and heaps of applications myself to the court, because I think it's going to have effectively a cultural shift or a deterrent effect, because if you as an instructive lawyer know that you've got to justify to the court why you aren't using an ADR process, unless you've got a very good reason to do that, it can be quite difficult. But Tony, I don't know if you have views on that.
Yes, I agree with you. I think that the threat of having to go before a judge who may not be predictable in terms of the way they approach things, particularly if it's a short application that the opponent makes who wants to go to ADR, if you lose it, and it's a hearing of less than a day, the court can make a finding, and if it's adverse to you, it will quite likely make a summary order for costs and order immediate payment. I remember vividly how that happened just shortly before the CPR came in, when the practice direction introducing summary assessment of costs and immediate payment, and the fact that the solicitor must notify their client of a disaster within a certain set period of time. And all these provisions are still in the CPR. The Bear Garden, which had been a manic place where with hundreds of applications for rather tendentious interlocutory applications, suddenly became a haven of peace and calm, and there were just rather lengthy CCMCs, 3 or 4 a day. The life of the masters was dramatically changed, and of course the district judges.
And I'd expect really that the question of ADR, whatever form it's in, is going to come up at CCMCs and places like that. It'll be sort of, I anticipate, sort of drilled into the litigation process. So as I say, I think for large businesses, your ADR strategy or how you deal with ADR alongside the rest of your litigation is going to be very important. And there are lots of things that you can do and be quite creative about. So I think that's quite useful. And I agree with you, Tony, in terms of the sort of the bread and butter litigation that you might expect. Obviously, there's going to be that dynamic of how do we deal with things day to day? Is it going to be something we deal with outside of court so it doesn't get there? And I would just add a short note on the small claims, which is just to mention that, of course, small claims mediation is now in place, and it'll be effective for claims going forward. And I wouldn't be surprised, of course, if it was to be extended a little beyond the small claims at the moment. But Tony, I think you're about to say something.
Well, I was going to remind about that. And of course, there will be perhaps people here who are in-house lawyers in big businesses who deal with small money claims, who will find that they will need to develop their own strategy for dealing with mandatory mediation of those small claims.
Thank you. So Kelly, I mean, you mentioned there the litigation strategy and the impact on large commercial organisations. I think, I mean, Churchill was a case that concerned as an internal complaints procedure, and the court's effectively ordering well, now will be able to order parties to or to go through that process. So something for large commercial organisations to think about just on their general terms and conditions and complaints procedures with their consumers and customers. And then we also have mandatory mediation for small claims as well. So it's at all ends of the spectrum for clients to think about. And then what about the impact on the lawyers who are advising their clients? What's Kelly, just as a practicing barrister, what is your assessment how Churchill and the CPR will affect how lawyers advise and work with clients?
Well, I would just observe that certainly I'm seeing, as a matter of practice, a great deal more interest in looking at the wider fabric of how a dispute might be resolved. That's the first thing. The second thing is that I think it'll be very difficult now as a lawyer not to consider ADR at every stage that you're advising. So there are going to be, as I said earlier, there are going to be some moments where ADR is particularly appropriate. There are going to be some where you might think, well, you know, it would actually, this is the kind of case where you need a bit more information from each of the parties before you can effectively do something and so on. But for me, the key thing is that it's really essential now to start considering ADR at each of the key stages as you go.
And it's not any longer just a matter of being afraid of a sanction.
Yes.
I mean, the problem with sanctions as a driver towards mediation has always been that courts have been very reluctant to consider cost implications of refusal to mediate until the end of a trial. Well, as there are only trials in less than 5% of civil cases is issued, it's a pretty rare event for a case to get as far as a judge who has to consider making an order.
Yes.
Now, if it's going to be coming up at case management conferences or possibly occasionally on application by one party to force another party to mediate, this is all going to be done and dusted long before trial takes place.
And actually, Tony, that's a really interesting point because, of course, there is also the Online Procedural Rules Committee, which has been constituted and is beginning its work. And as I understand it, the OPRC will also be making rules about pre-action steps. And that introduces an advance, I think, which will be very interesting to see where they take the ADR piece there and the rules that they make.
Yeah. And we shall look at that, I think, in relation to the pre-action protocols generally, too.
Yes.
Thank you, Tony. I was just going to go there actually, but I mean, just to sum up, I mean, we have ADR. It needs to be something that lawyers are considering advising clients on all the way through. That's now, well, if the CPR changes are implemented, that's going to be codified in the White Book, and courts are going to have a duty to look at it at case management conferences as well as lawyers. So we've talked about Churchill, and we've talked about the CPR and the draft changes as they are, which the consultation I think runs till around the end of May, so it's quite a tight timetable.
28th, Richard.
28th, thank you. Tony, there are also some, I think it was last year, the Civil Justice Council conducted a review of the general pre-action protocol, and
yes.
that also has some implications for ADR and mediation.
Yes, it does. I think it's going to move rather more slowly than the CPR reforms because the Civil Justice Council has set up a body to review the effect of pre-action protocols. There was a consultation on an interim report some time ago, and the first part of their final report was published last summer. And if lawyers had listening to this program, thought that they only had to worry about life once proceedings are issued, I'm afraid you're going to have to start thinking again if these particular proposals come into effect. The individual protocols are still to be considered, but the report that came out last year includes a draft general protocol to replace the practice direction pre-action conduct one in place at the moment. And there are certain fairly dramatic proposals embodied in that report. There are said that there will be 3 steps to pre-action behavior. 1, exchange of information. with a strict timetable and an obligation to be honest and open. Secondly, a dispute resolution stage. So here we suddenly get possibly an obligation to consider ADR, to use the phrase for convenience, before issue. And thirdly, a joint stock take if settlement is not achieved by the dispute resolution process. And that seems to me to describe quite a useful process in which mediation could well be engaged in, not only for the purposes of seeking dispute resolution, but also if it doesn't settle, the parties can sit down at the end of a mediation and say, okay, let's do our joint stock take now and see why proceedings have to be issued, what the proceedings will amount to, and so on. But the report also emphasizes the fact that the protocols had really been pretty poorly enforced, or the obligations under the protocols have been pretty weakly enforced by the courts, really since they were introduced. They give a guide to pre-action conduct, and occasionally they've been used, as it were, to say this was unreasonable pre-action behaviour, and we will impose a sanction later on. But actually, it's really been more overlooked than anything else, and you think it all comes out in the wash. Certainly, there seems to be a determination to make the obligations under the pre-action protocols pretty enforced. And indeed, again, there's a suggestion that compliance with the protocols should feature in the overriding objective. So will be some time before they come up with proposals in relation to the other protocols, the specific protocols, and I can't see how the whole process can be regarded as complete or in place and certain until that's happened. And I'm sure that's going to take a year or two to do, because there'll have to be consultations with the interest groups that fall behind each protocol. But judges will know what that says. They will have read it, and they might well find themselves enthused about the prospect of being tougher about the expecting people to observe the conditions of the protocols as they stand at the present, which are actually quite tough, and they're supposed to be in place to encourage the possibility of pre-issue settlement. And they don't really need any kind of new legislation or rule change to be able to enforce the requirements of the protocols. They can simply choose to regard them as being rather more enforceable than they used to. And certainly the atmosphere change that Churchill has created, I think, might well lead to that. Kelly, I don't know whether you agree with that analysis.
Yeah, I do, Tony. But what I wanted to pick up from what you just said was that interesting notion of the stock take. And what I was thinking about there is, obviously you've referred to it in a pre-action context, but I think it's very interesting because, of course, lawyers are really well placed to do that stock take with their clients, whether it's pre-action or at other stages in the dispute. And so for me, that's the real value of having lawyers involved in your disputes when you're looking at ADR and ADR strategy, because whether it's a pre-action stock take or it's before every substantial deadline that comes up, which involves a chunk of work, that's a great time for a lawyer to have, I think, a very significant and very important role in advising their clients as to how the litigation could proceed from this juncture, whether some form of dispute resolution is appropriate, and so on. And I would also just add, I mean, my experience, perhaps I'm a bit disposed towards lawyers, but my experience as a mediator is that lawyers are almost always very helpful in a mediation, whether that's around helping their clients to understand the position that they're in, whether it's about assisting in negotiations or presenting points and so on. But it's commonly said, let's keep the mediation conversation away from the lawyers and just for the lay clients. I don't agree with that myself. I think there is a really significant and useful input that lawyers can give at the mediation. And I think that's part of that sense of a lawyer's role in relation to ADR is around stock take. It's around looking at what best suits their client, both legally, commercially, and so on, and assisting them with that conversation throughout.
I think that will give people tremendous job satisfaction. I entirely agree with you with the importance of lawyers in mediation. On any complicated case, I would hate not to have a lawyer there who is partisan for their client, who therefore does not lead to a confusion about my role, not being an adjudicator or an advisor. lawyers are absolutely vital to the success of mediation. I think it's just going to seem like a different kind of lawyering.
Yeah.
And I think it will be a very stimulating kind of lawyering too. In a sense, there'll be, litigation lawyers will find that they are in the deep thick of negotiating transactions and looking at the future for their clients' benefit, as well as trying to produce a process that decides who was right and who was wrong 4 years ago.
Exactly.
I think it's going to be a very exciting time for the legal profession.
Thanks for that. I mean, there's a huge amount in there. I mean, we've got changes to the CPR, which obviously rules that will be enforced, and the pre-action protocols, which it seems likely that this is going to change the court behaviour, and that's going to have just the weaving of mediation and ADR through all the stages of litigation is going to have an impact on how lawyers practice, and I guess there'll be more of a focus on negotiation skills, mediation, advocacy for solicitors and barristers as a consequence of this. Did you have any? Would you agree with that? And is there any final comments on the CPR and PAP changes?
But just to say, I think I think the change of culture is probably beyond recall. There will be those who will grieve about the loss of red meat litigation, perhaps, and there will be those that will still probably find the odd moment when they can indulge in it. But I think they're going to have to temper that enthusiasm, because I think they will find that judges will change about this. I mean, there have been different views, strands of view amongst judges. Let's be honest about this. In some of the cases in recent years, some judges have been very enthusiastic and firm about sanctioning people for refusing to use mediation ADR. Other judges have been very reluctant to do it. I think what's really interesting about these changes, triggered by Churchill and the changes in the CPR, is will the reluctant ones change their thoughts, or will they find a way to perhaps to kind of satisfy their reluctance in a different way? I just don't know the answer to that. But it seems to me that, as we've already said, there are less likely to be post-trial costs sanctions hearings than there were, because the whole issue of ADR will have been buttoned up beforehand. And of course, all you have to do, frankly, is to do the mediation. And if it doesn't settle, you're in the clear. You can't. It must be emphasized, and I think it's really important for judges to protect mediation in this sense. People must not be able to be criticized for even unreasonably refusing to settle in the mediation. Once you get to a mediation, what goes on in the mediation must be off the record, and you must be free to decide that your interests are not satisfied by the terms that have been proposed, and you must be free to go to trial without any criticism at all. And that's one of the areas that I think that stuff I've been writing about, the confidentiality of the process, I think is a really, really important topic, and I'm hoping that judges won't mess that up.
I agree with you, Tony. I think just to reflect on one or two of the other points that I've often heard come up in this context around, well, aren't there some disputes that really just have to go to court? And to be fair, in my experience, first as a solicitor, then as a barrister, I've certainly been involved in cases where it was necessary to go to court to have a particular point of principle determined. And I don't see those types of cases going away. There are some where, looking at one of the cases I was on, effectively the government body couldn't just concede the point, and the taxpayer in that case wasn't prepared to concede their point either. There was very little that could be done in terms of the point of law, and it was a technical point, and it involved EU law and tax law. So, one of those things where it's sort of, minded to go to court. Now, if you were to take cases like that, where everybody firmly believes they need to understand what the status of the law is, and actually Churchill's a great example. We needed to know what the court thought about Lord Dyson's words in Halsey. Even in those cases, I would say that there might be issues where, for example, you could assist by using an ADR process, and that might narrow the issues between the parties, and it might save some court time. or it might give the parties an opportunity to understand each other's cases a bit better, and therefore the litigation from there proceeds a bit more efficiently or proceeds a bit in a different way. So my own view is, yes, there probably are cases which do still need to go to court, but even then there might well be scope for ADR processes to be used effectively.
Yeah, I mean, I think that's true, but I certainly don't think that anyone should assume that because there's a point of law at stake, it is incapable of negotiation and settlement. I mean, it's fine if I suppose we in the mediation world were reasonably optimistic that Churchill was going to go the way that we had expected, but for no other reason than the fact that Lord Dyson had already admitted 9 years ago that it was wrong. But the fact of the matter is that you don't want to go to court if an adverse precedent would shaft you. But what a mediation does is to provide a confidential environment in which you can revisit your risk analysis. And if your risk analysis, having heard the discussion that people have in the safety of the mediation process, tilts your risk analysis one way or another, you at least have the opportunity of deciding whether you're going to settle or not. And for instance, I mean, the retained organs litigation back in the mid tweenies or noughties, where they are. The great success in that story was the settlement of the Alderhead case, which was settled as a mediation where everyone got something they were satisfied with, which the court could not have ordered. And the chunk of the group litigation that went to court came a cropper. And so it's very important, I think, to make sure that even that point of law is something that you really want to take to court, and that there isn't a price that you might be prepared to pay or receive to avoid an adverse outcome.
Exactly. And for example, if you had very complex litigation, you might think, well, you know, there's a point on liability that we would like a court to decide on, but that doesn't mean that the following points on quantum need necessarily to be dealt with by a court. And you might, for example, think, well, you know, it's sensible to get the liability point dealt with. On quantum, we'll look at some form of ADR process. And of course, when you're in that process, that then opens the door to whether the settlement is going to stick strictly to the legal points or whether you might take into account some other points. So there's all sorts of creative ways you can weave ADR into your strategy, even if you do think there is something that needs to go to court.
Well, thank you both. I mean, just to sum up, we've got case law allowing judges and courts to order mediation. We have CPR changes, and thank you for your thoughts and comments on how that's going to essentially embed ADR in every stage of the litigation process. Tony, you have encyclopedic knowledge of mediation case law and cases. I believe there have been one or two other important mediation case law developments in the past 12 months.
Nothing as important as Churchill, I have to say at the beginning. And you're going to get, I think, a paper that I drafted, which has got some references to recent cases. One of the interesting things about Churchill, actually, is that on the quiet, ticking along in the background, there's a chain of cases which started back in 2012 where judges seemed perfectly enthusiastic about ordering a stay for ADR, perhaps ignoring the effect of Halsey. They started with the case of Andrews and Barclays Bank, which is all about PPI mis-selling, then followed much more recently by the Grenfell Tower litigation, where Senior Master Fontaine said, against the wishes of one of the groups of litigants, no, I think that this ADR process that's been set up must take its course. It's going to happen before you can proceed to go to court. And another case called Hossain and Chowdhury, which was a chancery case, a similar thing happened, and also another group litigation case, Hammond and UCL, where students were complaining about inadequate teaching during COVID, and there again the judge said, no, I'm going to order a stay. It's got to go through the university's dispute resolution process. So interestingly, they were simply relying upon the existing wording of the CPR, which authorizes stay for various reasons. And so in a sense, one might say, what on earth was all the fuss about with Churchill? But nevertheless, we've got Churchill, and now that is absolutely clear that both a stay and an order can be made. There's another case where, in relation to a failure to settle a disputed inheritance case called Stoney, Anderson and Abbas, the claimant offered to mediate at the outset, but later declined. Claimant won at trial, but lost 50% of their costs, having refused to mediate later. So cost sanctions were being made. I just don't know how important those are going to be in the future. Another case on ADR clauses, contract clauses called Kojima and Children's Ark. There again, the court underlined that a dispute resolution clause has got to be clear to be enforced, and that they will, a party will not succeed in getting a stay for ADR if the process that was proposed in the clause wasn't absolutely clear and the procedure clear. So make sure that those clauses are drafted thoroughly and carefully. And one other odd case called Denny and Babet, a party's failure to perform agreed settlement terms led to an order for indemnity costs when the case went back to court from the date of the failure to observe the terms. But I think, as I say, nothing quite as important as Churchill.
Well, I mean, it has been a very significant year. We have Churchill, we have the CPR draft changes, we have the pre-action protocol, we have mandatory mediation for small claims. Kelly, have you got any thoughts on where we might be going next in terms of the landscape of ADR?
My view, and I accept I may have some biases here, but my view is that we're looking at much fuller integration of ADR processes. I think there are going to be many more opportunities for parties to take the initiative, whether they're big businesses or whether they are sort of, bread and butter litigants. And I was interested, for example, I mean, I dread to raise Hugh Grant, but I'm going to. I thought it was very interesting to see how effective Part 36 was in the dispute that Hugh Grant has had. And, I'm sure many of you will have seen that the comments that he made around Part 36, that effectively he was advised by his lawyers that despite having been offered an enormous settlement sum, he was at risk of an enormous amount of cost because the expense of Mr. Murdoch's lawyers had he not won an equivalence or higher sum at trial. And I do think there is now a cultural shift towards ADR becoming one of those types of issues where you have to consider quite carefully when it's right to engage and how you might be sanctioned if you don't.
Thank you. Yes, indeed. If Hugh Grant is being put off by a Part 36 cost consequences, then there's a major threat to everyone. I would have thought he could have afforded it. But
I would just say, Richard, though, if you don't mind, that I think it also illustrates something interesting, though, because Part 36 and potentially ADR, it might be said, well, look, doesn't that deprive people of going to court? Because there are going to be many people who would have wanted Hugh Grant's dispute to go to court, so that the things that he might have to say about that process might be done publicly. But I think it does also demonstrate the point that actually, when we're talking about the need for things to be public, we are also talking about real people who have actual cost consequences which apply to them, whether they're Hugh Grant or somebody with perhaps slightly shallower pockets.
I think we can be reasonably confident that there are going to be enough stubborn mules who find settlement terms unattractive or offensive, not to deprive the common law of the oxygen of precedent, which was one of the things that some academics have expressed concerns about in the past. I think the lawyers are going to need to exercise very considerable judgment as to whether they advise their clients to settle up the terms as emerge or press on to court. The Hugh Grant case, in a sense, does highlight the fact that clients may be risk averse, and it'll depend upon the degree of risk aversion of a client. Set aside what he wants to achieve, she wants to achieve, to make decisions about this. But certainly the whole point about Halsey being wrong was that it does not deprive parties of the right to go to court.
Exactly.
And it's a matter of judgment as to whether you do settle or whether you do take the matter to court, but nothing stops people from going to court if they think it's in their interests in the broader sense to do so.
Yeah.
Well, Tony, Kelly, thank you ever so much for your thoughts. We have, I think, reached the end of our scheduled discussion time, and we are moving into the time that we have identified or allocated for some questions. I did have one question, but I would encourage everyone in the audience, if you do have things you would like to ask, please put those in the chat, and I can see Frederick. We'll pick those up and put those to Tony and to Kelly. Just one from me is this is an election year. And it seems likely there will be a change of government. Do you foresee any changes? do you foresee any changes that well, the next government may wish to introduce, which may have an impact on ADR and mediation?
Well, as long as they don't want to treat justice as a cash cow to save public expenditure, it seems to me that the Ministry of Justice has been deeply starved of funds increasingly, and as they are responsible for prisons as well as civil courts, we know where some politicians think that the money needs to be expended. On the other hand, my own impression, and Kelly will be able to answer this better than I think, I have the impression that the Ministry of Justice has enthusiasm for ADR developments. They are working in partnership with the judiciary over these developments. It's always been a great pleasure to me in this jurisdiction that the judiciary have taken a considerable lead in relation to the development of ADR, but for them to do so in partnership, in a sort of equal partnership with government, that seems to me to be a particularly powerful thing. And I'm not sure that every other jurisdiction has had the luxury of that kind of arrangement. But so I don't think that there will be a major change. But Kelly, what do you think?
Well, I would just observe that there's been a great deal of really positive engagement by this government and by the Ministry of Justice on ADR, whether we want to call it ADR or whatever else we want to call it. And I would hope that that's something which would continue if there is potentially a new government or some change, because it's so important. And I sort of feel that actually the ball has started rolling, and I think it'd be quite hard to stop it now. So I would hope to see, if there is a government change, continued engagement.
Well, thank you both. I can see Frederick, and I understand we do have some questions from the audience.
We've got quite a few questions, so thank you all. It was really informative, and actually I think what's really exciting is, Richard, if I can ask you to stay on, then I can ask all three of you these questions. We can sort of dot them around. It did occur to me as you were speaking, maybe we can convince Hugh Grant to be in the movie of ADR or mediation at some point and play himself if he's not willing to go. We have lots of very interesting questions actually, and so I will just take you through some. We've had a question about if, as ADR or mediation becomes more compulsory, whether large clients will be under an obligation to disclose more how they do ADR, or what types of, what their preferred process is, and whether it'll become much more standard for them, or if it's still sort of more of a, you can do whatever you want each time. And so whether the changes from Churchill will make people have to do it in a certain way. And I was going to say, does anyone, I mean, Kelly, I saw you nodding.
Kelly, I think that's one.
I'm quite enthused about this question, yes. Can I start?
Whether you will, as a major client, be saying, this is how we always, I don't know, just picking someone massive, this is how we always, as Transport London, do a mediation over a certain value or something.
It's a really interesting question. I think there are a couple of things in play here. Thing number one is whether it's the type of process which a court would want to know whether or not somebody has participated in a mediation or an ADR process. And I think my instinct and, looking at what we said in Churchill and what Churchill actually came out as saying, it's very clear that parties can be ordered to participate in mediation. The other question of whether there can be an assessment of how successfully or how thoroughly they participated was not something we got to in Churchill. The court asked about it and chose not to go there in the judgment. So number one, there's an issue around whether or not this is a process where the courts are already engaged, and therefore there is a question as to how the parties have engaged in that sort of process. But then the second question around whether or not there needs to be more disclosure, of course, there is a question about whether those ADR processes are ones which are going to be public or private.
Mhm.
And when I say public or private, I mean, for example, you might choose, if you're a large business and you want to compensate people, to set up a public scheme, or a scheme which is very well known, but the decisions may be private. Or, there's all sorts of things you might choose to do. And so that question about what's disclosed or not is an interesting one, but I think it's up to the process designer.
Brilliant.
I think there are a couple of things to say about it very quickly. One is, I've always drawn a distinction between pressure to take part in mediation, which I've been agnostic about, but tended to think it didn't really damage the process if people are put under process, and the absolute voluntariness of being involved in it once it started, and the importance of being able to leave the process without any adverse reaction from anyone else. And although, as happened in Ontario when they first introduced mandatory mediation there, there was said to be 10-minute mediations where people turned up and ticked a box in order to be able to satisfy themselves. In a sense, I'm not too worried about that, because I think we mediators will be happy to take responsibility for persuading people to stay and to show them that there may be some benefit in doing so. So that's one point. The other side I'd want to say is this: it's something emerging from the pre-action protocol paper. They draw a distinction there between two types of ADR. When we're using this phrase ADR, although we don't really like it, and I think there's going to be quite a lot of discussion as to what nomenclature we're going to end up with.
Yeah,
we may have an intermediate stage on that before it's actually finalized. But leaving that aside, two types. One is the type which is managed by a neutral. So mediation, neutral evaluation on the one hand, and ones which are not, like, for instance, an internal complaints procedure as was available in Churchill. What happened in Churchill, the district judge clearly wanted to, or contemplated penalising Churchill for not using the ICP, but I'm not so sure that judges are going to rush to order people to use an ICP. For one reason, that's normally a pre-issue event, ICP. And I think we may find that the judges will be minded only to order people to use ADR processes which are managed by a neutral, although they may still reserve the right to penalise people for failing unreasonably to use an ICP, because pre-action, for instance.
Thank you. Richard, I don't know if you had a comment, but
I was just going to add. I mean, Churchill says you can order parties the courts can order parties to use ADR procedures. And I think the question was about disclosing how companies and organisations do this. So
yeah, and whether it's going to become just this is what we set to do every time, and I think I'm hearing lots of different things.
I guess clarity of process information for parties and so on, and disclosure case specific stuff is separate, but a process that is understandable, comprehensible, and clear and transparent for people to enter into, I would think would be considerations for companies when they're putting together an ICP that they want people to use.
Thank you. We've had a few questions about costs coming up, and particularly two things. One is, if you do move towards a compulsory mediation, how will that affect no-win, no-fee cases for solicitors? And also whether we have had a question as to whether we think we'll get to no-win, no-fee mediations as well, where and that there's already suggestion as to, guaranteed settlement or your money back type thing. Dangerous, possibly, but
absolutely. I'm dead against no-win, no-fee for mediators. Look, we have no stake in the outcome. We have no skin in the game. We run a facilitative process. Whether the case settles or not is down to the parties and not down to us. I expect the market will find a way of firing us if they don't think we do a good job in running a process. But certainly, I don't think you'll find any mediation order. I think there was once a mediation organisation that said no settlement, no fee. I don't think it lasted very long.
Okay.
On the question of no-win, no-fee, I don't mean no-win, no-fee. I mean
lawyers.
On the question of CFAs and so on. I mean, I spend my life dealing with mediations with claimants on conditional fee agreements, and the main impact they have is that usually when the last offer is delivered, there is a lengthy period of time while the claimant solicitor explains to the claimant what they're going to get in their hand and what is going to be deducted. So, I mean, certainly CFAs make participation in the litigation process possible. That's what they're there for. They're there so that people don't have to find a huge sum of money up front to pay their lawyers and can get access to justice. And sometimes they don't get every penny that they thought they might be entitled to because their lawyers were good enough to, as it were, sub their litigation costs by work in progress. So I've never found that CFAs get in the way of a successful mediation. It's just they slow things down a bit at the end when the clients feel a little bit disgruntled about the fact that they've got to surrender a certain amount for their success fee and this and that.
Thank you.
Is that your experience in commercial cases?
Yeah, I was just going to add a slightly more pragmatic point, I suppose, which is that if you're thinking about CFAs now, maybe one of the things you want to think about is how you define a win for the purposes of the CFA, because if there is a much greater likelihood of going to an ADR process, you know, win may not necessarily mean win X amount or win the litigation in a particular way or win certain points in the litigation. It may mean coming to a positive conclusion in some way that you might want to define in your CFA. So I think that's probably worth thinking about when you're looking at CFA terms.
Thank you. We had a question as well, bit of a technical one actually, which is about use of experts and whether or not you, so this actually came up within the context of clinical negligence mediations and sort of whether parties are, especially if they're quite low value, are going to struggle because they are suddenly at a mediation or they're at an earlier stage when there hasn't been expert evidence or that there needs to be that for defendants particularly or claimants and defendants to be able to reach assessment. Just asking both of you, we have several questions by the way, but do you have any views on the use of experts or waiting for experts in relation to mandatory mediation or court ordered?
Shall I go first? Oh, sorry, Tony.
In clinical cases, you have to have an expert evidence to get your case off the ground in the first place. However small it is. On the other hand, in an area like clinical negligence, where frankly there are excellent lawyers on both sides, relatively small sector, one would expect most competent lawyers, and they are mostly extremely competent, to be able to form a view as to how a case is going to go, whether an expert is a good expert, whether they can argue a point without an expert's report. Cases do follow the same sort of track, and I'm fairly sure that the cases can be resolved fairly, even at early stages with fairly rudimentary expert evidence available and often not disclosed or exchanged by parties. Kelly, as you were going to say something about this.
Yeah, I was just going to say, I think it depends on the type of case and the type of expert evidence and the issues to which the expert evidence goes. I've certainly in not the types of cases you're talking about, Tony, I've seen cases where there is an expert, there is evidence, but it's not the entirety of the case. I think there's a strategic decision to be taken around the type of issue that the expert evidence is about and when, therefore, you think about doing your mediation type process.
And if actually if it's a big case and you can afford it, and I can think of one case where it nearly happened, but only one in 30 years of mediation, get the experts along and stick them in the middle, see which one looks more impressive. And you actually, it's a bit like a hot tub hearing in the High Court. That's what happened there. And one side thought their expert wasn't as good as they had hoped. So, a deal emerged. So it's another way of dealing with running a mediation.
And I've certainly seen experts at mediations as well, Tony, so I agree with that.
Thank you. We have a question about if both parties are incredibly reluctant to go to mediation, but are going down that route, should they be disclosing that to the part? How should that be disclosed to the mediator? Should people be aware of that this is essentially court ordered? We don't want to be here. You know, what maybe as mediators, actually, what would be your best advice to a client who that's the situation?
I really like to know that, because I've certainly had mediations where one or both parties have come along and said, we really don't want to be here, or we don't believe in this process, but we'll give it a go because we're supposed to, or whatever. And I think it's important from my perspective as a mediator to know that, because there is work to be done then around helping the parties to understand what the purpose is, what mediation can do, and to help them to at least to work with whatever their concern is about the process. You know, if it's a public body and they say, oh, well, I can't mediate because I'm a public body, well, that's really helpful to know, because you can then work with where they do have scope and where they don't have scope. So personally, I like to know that, and it's helpful.
Yeah, I like to know that. I also like to check who's the person who thinks this in any given team, whether the client and the lawyer are absolutely aligned on that. But just a warning to people, I think one of the possibilities, and there have been a few cases of this kind that might happen, which might lead to particularly the directions hearing, consideration of an order being made, is if both parties simply say, oh no, this isn't a case for mediation. The judge may disagree with you. I mean, let's face it, you know, the worst kind of boundary dispute leaps to mind, where if it goes to court, then you're going to have, as happened in one case, of an 83-page judgment dealing with all kinds of things like lost modern grant, poor conveyancing plans, etc., etc., etc. It may well be that a procedural judge will say, plague on both your houses, as said by Sir Alan Ward in the case of Macmillan, Williams and Range, where both parties had refused to advise both lawyers had failed to persuade their clients to come to mediation. I think a court might well say, I don't care what you both think, you're going to mediate, and there could be adverse cost consequences, no order as to costs or something of that kind, even at that stage.
And Richard, thank you, Tony. Richard, do you have any views on sort of parties being reluctant, or whether there's any different way of handling it if they haven't chosen to go?
Well, I mean, we hear that arranging mediations quite frequently. I mean, I say the mediation is successful primarily. I mean, the settlement rates are north of 70%. Even if the mediation isn't successful, it can lead to benefits in terms of narrowing issues and bringing parties closer together. So there are, and even if it isn't successfully, gives, I guess, a client a way of speaking to their counterparty in a way that they may not have had if it's existing litigation for some time. So it can be either a productive experience in terms of a settlement or narrowing issues, or learning more about the opponent's case. And in context with the cost of litigation, it is mediation or other forms of ADR are inexpensive. So I would say, well, I think it's worth a shot. Obviously, you have to make that decision, but there isn't that much to lose.
Thank you. We have a question about different types of tribunal and sort of different types of final decision makers. So it's actually asked, there's a question about adjudicators and construction and various, you know, other things. Do you think that it will be the same sort of overarching theory and sort of process that going to mandatory mediation before any type of sort of court or tribunal or similar sanctioned thing, or is it really going to be about your sort of, if you're going to a court, that you'd have to do this, what the direction of trend is?
So for me, I think there are two things here. One is whether the changes will make their way into the rules. And I think, as I mentioned earlier, there is that question of, you know, CPR changes don't necessarily flow into tribunal changes.
Yeah.
But I would anticipate it might be something which does eventually work its way through. Where the CPR starts, tribunals will often have a look to see if it's something appropriate to go on into theirs. I think there are going to perhaps be some specialist tribunals which might take the view that they want to think for themselves about how appropriate mediation is in their particular area, if I can put it that way. So I think the resistance that Tony referred to earlier may, you know, then we may well see some of that. But I think in principle, there's no reason why the principle outlined in Churchill and some of the mandatory mediation schemes that we've seen now in the UK and elsewhere couldn't potentially be included in tribunals and other types of processes in due course.
Yeah.
Great.
There's an interesting question as to the extent to which arbitration and arbitrators can be persuaded to encourage people to mediate. And I know CEDR did a bit of an investigation into that some years ago, and I don't know to what extent that really happens. Of course, the CIR trains mediators as well as arbitrators, so there's an opportunity for crossover there, but I'm not entirely sure that it happens much.
Thank you. In terms of cases involving international parties or where they're choosing jurisdiction, do you think this will have an impact on choice of jurisdiction?
Well, we've signed Singapore. We haven't ratified it yet, but we've signed Singapore. So there should ultimately not be any downside to enforcement of mediated settlements. I'm not sure there has been a great difficulty about enforcing settlements mediated in the English and Wales jurisdiction. It was one of the kind of slightly empty things that happened about the EU directive, I always thought. But if we offer, I mean, the great thing about mediation is it is very comfortably cross-jurisdiction. The fact is that you don't have to prove that a case has a seat in England and Wales to be able to mediate it here. You obviously have to have lawyers who can understand how to advise people what the legal implications are and where the various bits of international private international law impinge upon a particular dispute. But the fact of the matter is, if there are good mediators here and there's a good process, then people will come here to get those mediators hired and to assist with the resolution of disputes, however international they are.
Thank you.
Can I jump in there really quickly, Frederick?
Yeah.
I was just going to say, I think the heart of this question is whether Churchill and mediation being so ingrained in the UK's litigation system effectively strengthens us as a jurisdiction in which to resolve disputes. And to my mind, the answer has to be yes to that, because without that, you are depriving people of an opportunity to find ways to look at their litigation properly. And with it, you have the opportunity to bring actually potentially quite complicated and difficult cases with the opportunity of having a private discussion about them. And I think that additional support by the courts for having a confidential discussion is really interesting.
Thank you.
Whether it'll put off the most aggressive of international litigators from certain countries who instinctively want to sue the pants off anyone, I don't know. But
I think not, Tony. I think not because
we can live without them, perhaps.
Well, I think not, because the point of Churchill is to preserve the right to go to court if that's what you really want to do.
That's true, absolutely.
And I think I think it's a maybe very short follow-on of this. I mean, people have asked actually about what the situation do you see in the rest of the United Kingdom, so Scotland and Northern Ireland, and whether that will be also influenced, obviously, Churchill to do with jurisdictional issues. Do you have any view, anyone, on Scotland and Northern Ireland?
Well, I did read in Lexology a piece by a Scottish law firm confirming that Churchill had happened. He did unfortunately describe it as saying the parties were ordered to use ADR, which isn't actually quite right. It said that the courts could have ordered ADR, but they didn't actually do so. And said, well, we'll have to be thinking about this in Scotland. I'm also next month talking in Ireland to a conference about where a scheme for personal injury mediation is being introduced by the Personal Injuries Assessment Board, being renamed in the Injuries Resolution Board now. And there they are very, I mean, the Irish Mediation Act is very firmly saying mediation must be voluntary, or participation in mediation must be voluntary, which is actually nicely ambiguous if you pick at it. It doesn't necessarily, to my mind, mean that people can't be forced into it. But there is, and there they will have constitutional issues. I mean, everyone rushes off in judicial review to the Supreme Court on the slightest question in Ireland, and so it'll be a while before I think they are able to adjust themselves to to this kind of thing. But I should be very interested to see what the reaction is to what I say when I announce that it is now part of our overriding objective to use ADR, and that courts can order it. Whether I shall return from Ireland.
I hope it's recorded. Tony.
I don't know. We'll see.
I hope Tony will be seeing that on YouTube. We just aware of time, and I think we probably got one. There's one question I want to do, and then maybe Richard to hand back to you. But we did have just a question about vulnerable court users, and sort of just any litigants in person, or if you're sort of working against or with a litigant in person on the other side, and sort of the impact of Churchill, particularly on litigants in person. So just any sort of comment on what you think best practice is, if that is who is on the other side, and there's sort of more of this sort of mandatory audits stance, what law firms should be doing.
Well, luckily or unluckily, my last 2 mediations involved litigants in person, claimants in person. So it's very much alive in my mind. I mean, the great thing about mediation is it does offer a human-sized activity. And of course, we have both responsibilities to litigants in person, not to let them be pushed beyond comfort, to make sure that they understand what's going on, that they have the opportunity of getting advice if they really, unless they really don't want it, but equally to hold a balance between the 2 parties, which we still must have, even if one party is represented and the other party isn't, and in a sense to sensitize the represented party to behaving in a way that isn't unduly oppressive or perceived as oppressive by the litigant in person. But I do cling on to the fact that it must be much easier for a litigant in person to cope in a fairly ordinary room with a human being who might be prepared to use their first name than to put them into a courtroom, into a highly technical arena where they really can hardly be expected to understand what's going on. So we do always worry about getting the right balance when we have litigants in person, but in a sense, at least we have a process where we can actually do that, and I think not feel that we are oppressing them.
Yeah. And Kelly, did you have a view on
Yeah, just a very short point, because this did come up in Churchill, this notion of whether mediators are well suited to looking after litigants in person who might be more vulnerable and so on. The Bar Council made a submission on this, and we responded. But I think one of the key things is, let's say if you're a CMC registered mediator, then you will be applying the European Code of Conduct on mediation, and that gives a host of important obligations as to how a mediator behaves, things like independence, transparency, and so on, and treating all participants in a mediation properly. So to my mind, there are already obligations in place as to how mediators ought to behave towards litigants in person. And just as a matter of practice, I would agree with what Tony says, that actually mediations can be really appropriate places for the host of things that a litigant in person or a vulnerable person might bring to a dispute, which perhaps may not be dealt with in quite the same way in a legal argument.
Thank you.
And in your new role, Kelly, you are going to be, I think, able to ensure that we preserve a high standard of ethical behaviour as mediators. It's very, very important.
I agree, it's crucial.
We not being yet a formally regulated profession with a kind of real structure for regulation, it's incumbent upon mediators to behave ethically, not just with litigants in person, but with everyone that we work with.
Thank you. I'm just going to hand back to Richard. I'm aware we have lots of questions in the chat. What we will do is we will, if there are any final, there are a few technical ones, we will respond to them as well afterwards. And we will give people Tony and Ireland dates, which are being requested in the chat as well, as to what's happening there. Richard, can I pass back to you, please?
Of course, pleasure. Well, thank you very much. I'd like to thank everyone who's joined us for this session. And particular thanks to Tony and to Kelly for sharing their thoughts with us on these developments. I am going to invite you both to provide perhaps one soundbite final thought on what we've been discussing today, what lawyers should be thinking about for 2024. I will go to Tony first. Tony, do you have a final thought for our lawyer audience?
good luck. Is what I'm going to say. Change is with you, and I think it's going to be very exciting. But it is going to need a thorough thinking through of what the implications of this is. But I can only say that I am personally relieved that I'm not in private practice anymore, but I do wish everyone in private practice the wisdom to see the way through, and the commitment and the determination to make a success of it all.
Thank you, Tony. And Kelly?
For me, there's no longer an A in ADR. So whatever terminology we end up with, or however this ends up working, I don't think anybody who looks at a dispute in a sensible fashion can treat ADR as something on the side and optional anymore.
Great. Thank you very much to you both. So I think we're just about to close our session. We're going to stop the recording shortly. I think this will be available for if you did want to obtain the recording, and we will be issuing a legal update, I think, with this video. Is that right,
yes, so we will send to everyone who's on this, we will send you an email. It may be this very soon, maybe the start of next week, with the recording and also a copy of Tony's text update on all of the cases that he mentioned and sort of the case law, so to give you more of a formal written legal update as well. But thank you for attending.